I said before, no need to apologise, and I hope that you haven't been too inconvenienced by waiting in a queue of customers. Yeah, there we go. Right.
My lady, my lords, the fourth point, which builds on the third, still on the topic of criminal matters. My submission on the fourth point is that exceptional reasons of public interest do not exist in all cases, and I emphasise in all cases, this is an extreme proposition, in which the legislative scheme is set up with a criminal sanction if a person breaches its requirements. And in answer to a question that my Lord Justice Warby posed to my learned friend, I'm afraid we do disagree with the answer that was given. That is, we respectfully submit, the logic of my learned friend's case. And it's the logic of her case because there is no true distinguishing or narrowing feature that she identifies here to prevent the breadth of proposition for which she contends. The fact of criminalisation is what is relied upon, no more, no less. And the reason we make the submission we do, that exceptional reasons for public interest do not exist in all of those types of case, it is as follows. The starting point is 2A and its importance and its application as a new rule. It's set up, as we saw, as a duty, and the duty applies positively to require no remedy to be given if, in summary, and recognising the recent guidance from the Court of Appeal in 70 to 75 of Bradbury, the decision is highly likely to have been the same. The basic object of that sort of rule was recognised and applied in advance of it even becoming a thought in Parliament's mind. It was recognised what the basic object of having something like the simplex rule was in those early cases. West Berkshire, which we cite in paragraph 19 of our skeleton, I don't need to go back to it in the raw, it's paragraph 87 of West Berkshire, Lords Justices Laws and Tracy, tab 2, page 63, para 87, but we cited it in para 19 of our skeleton, if you have that more readily to hand. It's the paragraph you'll recall, I think my learned friend went to it, but it's a paragraph in which they expressed the strong reservations about the proposition that the court should necessarily exercise its discretion to quash as a form of a disciplinary measure, whereas subsequent equalities assessment satisfied the court, I think there it was habitats perhaps, but never mind, same point, satisfied the court there would be no point in quashing the decision to the effect of doing that and requiring a fresh consideration would not have led to a different decision. So it's that theme again, the sort of theme that one also finds very, very clearly in Bradbury, and I referred you in Bradbury to 70 to 74 for the proposition that the focus is on the decision. But perhaps the other point to bear in mind in relation to Bradbury without needing to go back to it is how similar Bradbury was on the facts to what we have here. And the essential reasoning of the court when it came to apply the principles that you saw in 70 to 74 to the facts of that case, where we go back to the original decision, and the assumption we now make is that they would have had the requisite assessment in that case, habitats or equalities matters not. They would have had that. Question then is, would the decision have been the same? And the answer that they gave in Bradbury is yes, indeed it would, because in Bradbury, even without the assessments, they'd imposed certain conditions on the planning permission that had been granted, and they were identical to the ones that they would have imposed if they'd done the analysis or had the analysis before them in the first place. In any event, the purpose is to create that sort of realistic recognition, which is, again, might be thought consistent with broader realistic principles of public law, a realistic position, which is that if, frankly, the error of law would have made no difference, then you don't overturn it. And in relation to the consistent and correct description of that as the purpose of 2A, can I just invite you to go very briefly to Gathercole, which is a more recent decision of the Court of Appeal and is in relation to section 2A, 31(2)(a). It's in tab 7 of the authorities bundle, page 149, and the paragraph I want is 38. So tab 7, page 149. This is Lord Justice Coulson sitting with Lord Justice Floyd and Lady Justice Aspin. And para 38, which I hope is a side marked passage, that we respectfully submit as the consistent, both before and after, but certainly the consistent and correct description of the purpose of 2A. So that's why the rule exists, as it were.
Before we leave that passage,
Yes.
James, I want to ask you about the last sentence, which I have to say rather chimes with the way I've always viewed the judicial review process, that it is flexible and realistic. I don't know if you can assist us on something I raised in passing with Ms. McGuy this morning, but I recall that in a PSED case, Hurley and Moore, what the Divisional Court did was, having found that there was a breach of the PSED, they were not prepared to quash the regulation. This was the tuition fee increase regulations in around 2011.
Yes.
After the coalition government had come in.
Yes.
And so the Divisional Court found there was a breach of the PSED, refused to quash the regulations as a consequence because a lot of water had flowed under the bridge. But nevertheless, to mark the fact there had been a breach of.
Made a declaration of breach.
Exactly, and it's always, if I may say so, that the declaration is a highly flexible tool in the toolkit of a court, and that it can be tailored to do justice in the individual case.
Without over-remedying.
Without
over-remedying.
Exactly. And that's why I asked Ms. McGarty earlier whether she had ever been content with any such limit.
Yes.
And she's made it very clear that she's never been content and is still not content.
No.
If the appeal is allowed, that we would give any kind of limited bounty of that sort, and therefore the court is faced, as I understand,
Quashing or not.
with a stark choice: quashing or declaration of invalidity, which is the same thing.
Yes. Because the government will react by convention.
Exactly. We expect you to comply with a binding declaration.
And we do. My lord, yes, there's that example. There's another example. I don't know if my lord recalls. We haven't got it in the bundle. I can't quite recall the circumstances, but I think it was one of those good law project cases where a similar breach of the PSED, it's just the government's never read the PSED itself, but there was a similar breach of the PSED, and I think my lord came up with exactly the same solution, remedially. So it was a declaration to reflect that fact, but no invalidity followed, and it was there to reflect the seriousness of the finding and so on. But my lord, I take all of those points. The point I was on was really that the starting point as to why there isn't exceptional public interest reason in just because you have criminalisation, the starting point of that is to recognise that 2A applies across the sphere. It applies to everything. All things that might come to the administrative court, as it were, and involve the possibility of a remedy. And the new rule exists for those good, flexible, realistic reasons. And so the first point that flows from that is that if my learned friend is right, there would be extremely broad coverage, as it were, a wide range of provisions would suddenly, as it were, be disapplying 2A through the door marked 2B because they involved criminalisation. And not merely that, they would involve criminalisation. And the question that would then arise is, well, why is it that the mere fact of criminalisation should be singled out from the range of public law decision-making and its bases as a special category that has that effect of disapplying 2A almost automatically? Now, one can say criminalisation is serious, and of course it is. But I don't remake the point, all the points I made about criminal conduct following only if you choose not to comply with the law, as it were. But there are many decisions which do not have criminal sanction as the sanction for breach, but which affect people's lives in very, very serious ways. So why is the legislative purpose question, would Parliament have chosen to single it out, that is, provisions which create criminalisation for breach in that way? There's nothing at all in the language or the structure of 2B to suggest that 2B intended to cover that species of legislation as in effect a cut-out class from the operation otherwise of the mandatory rule in 2A. On the contrary, 2B is focused on exceptionality. It does not say whenever the court considers appropriate in the public interest. You have to certify, you have to identify reasons of exceptional public interest. And that does tend to suggest that this is meant to be a narrow exception to what would otherwise be an obligation of no remedy on that factual premise, no difference effectively, if 2A is in play. So we do respectfully submit that the idea that this creates some form of unspoken cutout from the reach of the flexible and realistic rule, to use the language of the Court of Appeal and Gathercole, of 2A would be a very surprising conclusion. So we respectfully submit that the position to which my learned friend is ultimately driven, and she is driven there, is an untenable one. The fifth point I wanted to make before coming to 2 or 3 responsive points to the oral submissions that were made to you this morning by my learned friend is to note that Mrs. Justice Lang decided that she did not consider it appropriate for reasons of exceptional public interest to cut out 2A. We submit that the test you apply when considering that conclusion is the wrong test. She was not wrong, we submit to do so. My learned friend criticises Mrs. Justice Lang on the basis that her reasoning was short in that respect, but we submit that that's an unfair criticism of the judge, given that almost no argument was presented on the point, and almost no positive case was advanced by my learned friend below, let alone one supported by evidence. There was nothing like the sort of argument that you've had this morning, or anything remotely approaching it in the court below.
That just reminds me, you don't have, there's no criticism because often court bundles are bigger than they ought to be. But it did seem to us that it might be useful just to have a look and see what was available as to what arguments were presented below.
The skeleton arguments below, for example.
The skeleton arguments below, focusing obviously not on everything else, but if there are extracts that can be provided. We've had an opportunity to have a look at the, this issue was touched on in yes, in the document that was presented in response to the application for permission to appeal, and we noted that in Mrs. Justice Lang's reasons for refusal, she referred to that document, but again, that's not in the core bundle. So if there's anything below that
indicates the nature of the arguments.
Yes.
Should we, on this point?
Within reason, obviously.
Yes. Well, should we try and identify some relevant paragraphs or not, and then we can give you a little clip.
Either side wishes to bring to our attention on that would be helpful.
Of course. We can certainly do that. In any event, we respectfully reject the criticism that the judge's reasoning was too short or unthoughtful in circumstances as I've described, and it might be thought to be indicative of that my learned friend has made almost the centrepiece of her legal submissions this morning, the decision in Ex parte C, the Lord Justice Buxton decision, you'll remember about the children in the Young Offenders Institution. Not merely is there no reference to that in the judge's judgment, but there was no reference to that at all below. And indeed, not merely that, wasn't even an authority that my learned friend sought to include in the bundle of authorities for the Court of Appeal. And we do submit there is a burden on the claimant if they want to ask the court to rely upon 2B, or indeed its analogue at the permission stage of 3E. If they're going to do that, they are bound, we submit, to produce a properly formulated and detailed set of reasons, supported, if appropriate, by evidence. None of that occurred, so we do not accept the criticism of the judge's reasoning as far as that is concerned, and we submit the test as whether she was wrong. 3 points I wanted to pick up on briefly before coming finally to the couple of points on authorities, but or penultimately to that. I want to say something about quashing at the end. But to pick up responsibly 3 points. The first point my learned friend sought to make, or put some emphasis on this morning, was that there was an exceptional public interest, as she put it, in complying with the PSED duty at the right time. And that was sufficient to trigger the application of 2B. The short answer to that, as a submission in relation to 2B, is that it suffers from the fundamental fault of being an entirely general point. There's no exceptionality about it. It's another attempt, albeit a slightly different one, to create a class claim, in effect a class exclusion through 2B from the duty that applies in 2A. Not merely that, so entirely general is the first answer we give. The second answer we give is that I've already made the submission in relation to the criminalisation point. It does involve, if my learned friend is right, singling the PSED out from a range of other public law duties for the purposes of 2B. It can't only apply to the PSED. If it only applies to the PSED, that would create deeply adventitious and extraordinary or incoherent consequences for the purposes of the application of 2B, because the PSED would be treated in one way, and every other type of breach of public law duty, including some fundamental ones like irrationality, would be treated in another. So that suggestion we submit is simply, as it were, restating the premise for the consideration that is the 2B and 2A consideration. And the premise is unlawfulness. You don't get there unless that is the finding. But to emphasise the public interest in people complying with the duty to do the PSED, which we know is a duty that requires them to do an adequate PSED analysis at the right time, is to do no more than to restate the duty. It doesn't assist you, you can't bring it back in at the 2B stage. So it's wrong in principle, it's entirely general, and it risks creating incoherence for the reasons I've given, there being no justification to split that type of duty out from any other public law duty. That's the first responsive point. The second responsive point is under the heading decision maker here is Parliament, because the orders could not be made other than with the approval of Parliament, at least through the negative resolution process. And there are 3 or 4 answers to that. The first of them is that, again, that doesn't create exceptionality. It would apply, if my learned friend is right, entirely generally to all decisions where the Secretary of State acts to make subordinate legislation, or at least acts to make subordinate legislation which have any form of parliamentary process attached to them, which most do, either negative resolution or affirmative resolution, as you know. You also know the theory of the law, which is why the Secretary of State can be judicially reviewed in relation to the making of subordinate legislation, The theory of the law is that although Parliament is involved in that process, subordinate legislation is made by the Secretary of State. It is not made by Parliament, even though Parliament is involved in that process. But my core point is that, again, it doesn't create exceptionality, it just creates a new class, a slightly different class. And so the same and second point that I just made in relation to exceptional public interest in doing the PSED at the right time applies here also. It creates, if that's the class that's cut out and no other, as it were, it creates adventitious consequences. Why is it that 2B is in play and always operates as a cutout of 2A, simply depending upon the form by which the original legislation or original decision was made? There are some constitutional difficulties with the question my learned friend poses, and my Lord Justice Warby asked us some questions about that. The question that she posed was, well, would Parliament have remade it? But that's a question which it's impossible to answer. You can't just say, well, that the procedural defect is a fact. You're having to pose, her very question poses, would they have done it or wouldn't they have done it? How likely is it they would have done it? Not only is that not the question that is remotely close to section 31, which asks the highly likely question in 2A of the decision maker, but it's impossible to see how that question could be answered predictively in relation to what Parliament would or wouldn't have done. And the moment you try and do that, you do start questioning parliamentary process and outcomes. But it's a question which is not merely constitutionally inappropriate to seek to answer, but that is impossible of answer. The final answer assumes that I'm wrong, even in relation to that. And my submission is that the question that she poses would be the wrong question anyway. The relevant question at the stage of 2B is whether Parliament would have done that, if that's the question you're going to address. Would Parliament have made or remade in circumstances in which it knew not merely that there had been a flaw in the original PSED analysis because it wasn't detailed enough, but in which, and this is the premise on which you get to 2B, i.e. the satisfaction of 2A, but in which 3 months later, the Secretary of State had done the correct analysis and the decision was no change in the orders. And that, of course, would cast the question, even if legitimate to be asked, in a very different light. So that's the answer to decision maker here, Parliament. The third point that my learned friend made was, well, there was an impact on individuals here which creates a specific and serious public interest of exceptional quality, so as to justify the engagement of 2B, because, as is evident from the later EIA, a number of dogs, I think 405 was the number, it matters not, a number of dogs were destroyed in that period up to the end of May 2024. And it is true that that is the basis on which the second EIA proceeded, but my answer to that point is the same as the one I've just given in my final answer to the Parliament is involved point. The whole premise of 2A and 2B is to ask first the question whether the outcome would have been the same, but for the legal error. And the finding, unimpeachable, unchallengeable as it is now by the judge, is that it would have been. Even if the legal defect hadn't existed, the decision would have been the same. So the premise which underpins the attempt to create a public interest through this door is false, i.e. that things would have been different. They wouldn't have been. That's the unimpeachable result of the judge's finding on 2A. I wanted to pick up on only two of the authorities, because some of them are obviously about different things or don't materially assist, even at face value. My learned friend first relied on the Riley case. You remember the Riley case at tab 1. That was a case, as you will recall, in which retrospective legislation was introduced to Parliament whilst litigation was ongoing, effectively. And what that case was about was Article 6 of the ECHR and the circumstances in which it was legitimate for Parliament, or even for Parliament by legislation, to interfere with litigation. And it's fundamentally about that. All of that case law, which would be very well known to you, about how compelling reasons are needed if you're going to do that, and the strictness of the test, and all of that, all of those Strasbourg authorities that you see cited in the judgment. It's that's the area of the decision. So there is no true analogy to jump from there to our situation, to the rules now laid down by Parliament in 2A and 2B. It's about Article 6. There's no analogue. The suggested analogue that my learned friend sought to make with that case was all to do with, as it were, retrospective approval, as it was put. There, the legislation was retrospective, and so altered the outcome of litigation. So that's her analogue, as it were. That's the attempted analogue. But the difficulty from her perspective, even taking that as its merits and leaving aside the fact that this was all about Article 6 and had nothing to do with this legislation, the difficulty with that analogy, of course, is that it's an attack on 2A. Because if the analogue works, it's an attack that says you can't do that, you shouldn't be doing that. This is retrospectively to alter. And she can't attack 2A.
So, James, can I ask you about a passage
Yes.
in the judgment? Because it struck me that...
In the judgment in Riley?
Yeah.
Yeah.
Page 20.
Yeah.
Paragraph 82, which was cited by Ms. McGarhy earlier.
Yeah.
I just wonder if you can assist us, because I'm not aware that this has been the subject of any higher authority. I don't mean any disrespect to the judge, but this is the first instance judgment.
I think this case went to the Court of Appeal.
Oh, did it? All right.
We can provide you with that copy. I don't think this was...
Certainly speaking for myself, I would like
You're
to
welcome.
see...
We certainly can give you that.
Paragraph 82
Yeah.
is not about Article 6. That purports to be saying something about the UK's unwritten constitution, and it may not ultimately matter in the present case.
But it's highly controversial as such.
Well, it may be.
Because of parliamentary sovereignty, amongst something else. Yeah. Well, I wasn't going to engage in a criticism of a case which I lost, but there is that slight problem with that paragraph. I agree. I mean, it's fine as an ECHR point.
Yeah, and you've explained that your submission is that properly understood, the outcome of the case can be readily understood.
As an Article 6.
An Article 6 case.
This is not dispositive.
But reliance was placed on paragraph 82 by your learned friend.
Yeah.
So if we're going to say anything about it, and we may not have to, but speaking for myself...
Well, my lord, I'm not accepting that as accurate, if that helps. If we have to argue about that at some future point, we will.
Yes.
But, I mean, the case, as I recall it, was frankly about Article 6, which obviously did bind us because of the Human Rights Act. So that's what I want to say about Riley.
So the case number 1 went to the Supreme Court, didn't it?
It did. It did. It did. This was all about shelf stackers, if you recall. It did. C, I was going to deal with as the last authority to deal with, or specifically to deal with, and a number of points to be made about C. Again, my learned friend entirely fairly accepted that nothing in C was truly analogous, and that really is our first answer to that. This was not a section 31 2A 2B case. And there is therefore no true analogy to be drawn in terms of the factors relied upon by the court in C or the outcome. The court was simply not engaged in the exercise that they were engaged in there. They were engaged in something like the 2A part under old-fashioned simplex rules, but nothing more. So it doesn't really go anywhere near the issues which you have to address in relation to 2B. It might also be thought, without making anything to do with the judgment of the personal, as it were, but it might also be thought that the court was evidently unimpressed by a number of different features in the case. I remember it well because Mrs. Justice Leaven, before she was Mrs. Justice Leaven, I remember coming into my room and saying that having taken over the case from me at first instance, I had dodged a bullet. But it does look a bit like that. There were a series of factors that the court evidently regarded, no doubt rightly, as entirely egregious that affected the outcome in that case and may explain some of the more, some of the strength of the views expressed by Lord Justice Buxton, but we respectfully submit that nothing in truth can be drawn of any real use or generality from the specific facts of that case to ours. And indeed, in fairness to the court, I mean, it was a pretty unpromising looking context in which to have those sorts of arguments, involving, as it did, the possibility of using real and serious force against children in a context in which they were the responsibility of the state through detention. I wanted finally to deal with quashing, which I know the court is on to and has asked a series of questions about, so little that I can say about that will add much to the sum of human knowledge, but I will reiterate the point that this is not a case in which what is being sought or what was ever sought is a declaration in the narrower sense of that term. This is a case which is all about quashing, or a declaration which would be tantamount to quashing. And that does raise a concern, and it raises a concern particularly about the possibility of over-remedying, which my learned friend was constrained to accept her outcome would involve. We know from the judge's reasonings, which cannot be undone at this level now, that the conclusion was that from the end of May 2024, the legal fault had been rectified. So we are really talking about a period of time from the 1st of February 2024. You'll remember I took you to the appropriate date. I think it was under section 1(3) of the Dangerous Dogs Act 1991 and the order that gave effect to that. It was, so the relevant period is not from when it was laid or made or anything else. It's from when it became effective. When did it go live? And it went live on the 1st of February 2024 and then it ran till the end of May with the legal flaw still in play, as it were. But if the outcome of my learned friend's argument succeeds in this case on her conception of it, everyone effectively would have any criminal conviction undone, irrespective of whether they fell within that period, they fell within the longer period thereafter. And finally, in relation to that, and more fundamentally in relation to that, perhaps I should have started with it, but we know that in relation to the quashing remedy, that is simply an example of a remedy. It doesn't, as it were, touch any of the analysis, focusing on the fact that as quashing doesn't really touch any of the analysis that precedes it. In other words, the 2A, then the 2B analysis. You still go through the same hoops, and the hoops have been gone through by the judge, and the answer is, if the legal flaw had not been made, the legal error had not been made, and you go back to the point at which the original decision was made to make the orders, the outcome would have been exactly the same. The decision would have been identical, which makes it even harder to justify any sort of remedy of quashing unless there are exceptional circumstances, and no attempt is made to say that a quashing remedy is in some way something which is relevant to exceptionality for the purpose of 2B. So those are my my submissions in reply to them.
And no one has ever suggested that, said you couldn't have a quashing order which was limited in time.
No.
That's common ground.
No.
Have you ever come across a court making a declaration of invalidity for a limited period of time in the past? I haven't.
My lord, I haven't. I mean, the truth of it is that that is the logic of the judge's finding. There was a period of time for which the legal error was in play, but I've never come across an equivalent declaration. One can see difficulties with doing a formal declaration of that kind.
It gets into potentially very
complicated.
Very complicated territory about legislation being at different times valid and then being resurrected.
And in fairness, my learned friend doesn't contend, and she couldn't do.
She doesn't ask for that, and it seems to me, at least, unless anyone tries to persuade us otherwise, that it's impossible for a court.
Yeah.
It just doesn't seem to be part of the judicial role to be done.
I respectfully.
Either quash it,
yeah,
or equivalent declaration.
Yes.
Or we don't.
I respectfully agree, and the difficulty that creates for my learned friend is the one that the court pointed out when she was making her submissions, which is that necessarily entails over remedying. So if you do get to the may bit of 2B, that would be a pretty powerful factor against. It's a question, my lord.
That may explain why the wording of the judge's order.
Yes. Well, the judge was obviously, I mean, I'm sure the order was agreed. I have no recollection of it being agreed, but I'm sure it was. But the judge was trying to, as it were, reflect her finding in the judgment without getting into that sticky territory, and whilst making it clear that she was not granting a substantive remedy because of her conclusions under 2A and 2B. So one can say, well, that's a little bit of an unhappy compromise. It's neither fish nor fowl in remedial terms, but one can see why the order looked like that. In a way, it was like a preamble introduced into paragraph 1 of an order. There's nothing operative about it, but it was like a preamble. And I don't quibble with that. I'd be in just the same place if the judgment had said what it said and paragraph 1 of the order only contained the second sentence, as it were. Those are my submissions, my lady.
Thank you very much.
Very briefly, Nathan. In case of Bradbury, I don't ask the court to turn it up, but Bradbury did not consider exceptional public interest at all. Bradbury did highlight that every case was fact and context specific. In Bradbury, the decision maker did not have before them the finalised assessments from Natural Resources Wales about the risk of damage or pollution to the Road. But the decision maker did have the draft ones, which said that there was no significant risk. So the outcome was bound to be the same. And the question of whether the development in that case would pollute the River Wye was going to be answered in exactly the same way for every single person. Whether it was the claimant in that case or any other member of the public. And the decision in this case is very different on its facts. And this may very well be a reason for which the public sector equality duty should, in this case and maybe in others, require a different approach. As far as I'm aware, the researchers of both sides have not found any case in which the court has used section 31 to deny a remedy in its entirety in a case in which secondary legislation has unlawfully been made. In Hurley and Moore, which predates the legislation in any event, a declaration of some sort was made, even though quashing was not granted. Both sides have referred to the Christchurch case, neither in oral argument, both dealt with it in our written submissions. And in that case, the finding of the court was in fact that the regulations were not ultra vires, and even if they had been, the relevant ultra vires part could have been carved out and the rest of the regulations would have been valid. So even in that case, that's not authoritative proposition. That a remedy will be denied and legislation to be made unlawful. But I don't seek to argue that there is a proposition of general application, that there will always be exceptional public interest in granting a remedy when secondary legislation is involved, because I don't need to do that. Because in this case, the secondary legislation in question, created by its effect on Section 1 of the Dangerous Dogs Act, not just criminal liability, but the potential for a defendant to go to prison for up to 6 months. And that's Section 1.7 of the Dangerous Dogs Act. And the relevant failure in the public sector equality duty related to the position of vulnerable people who were intended to benefit from the exercise of the PSEG, and whose vulnerabilities could and should have been taken into account in the creation of criminal offences. And as I started my submissions this morning, in November 24, they were, with the addition of the provision that a person too ill to keep their dog could lawfully transfer the dog to somebody else. A direct benefit to people with disabilities not granted when it first became unlawful to own an XL bully without registration on the 1st of February 2024. And the risk of loss of liberty makes this case in my submission highly analogous to that of Abid, the unlawful detention case, which I've already taken. My learned friend submits that there is no exceptional public interest. But in my submission, in a situation in which Parliament, through use or through not invoking the negative resolution procedure, essentially put a path to approve legislation without knowing of the unlawfulness, when the orders created criminal liability with the penalty of imprisonment, with the vulnerability of individuals not considered when the whole point of the exercise they should have been, and particularly when this criminalising legislation was imposed so fast. In my respectful submission, is if that does not engage in exceptional public interest, it's very difficult to imagine what would. And my learned friend submits it is impossible to answer whether Parliament would have done the same thing had it known the true position. And he says that's not the right question, because the question asked in 31.2 is would the outcome have been substantially the same had the Secretary of State acted lawfully. But I'm not seeking to address that question. I'm seeking to address the public interest question, which is wholly different and which is not constrained to consideration of what would have happened had the Secretary of State behaved lawfully. In my submission, if one cannot say, and the Secretary of State concedes that he cannot say whether Parliament would still have approved this legislation had it known the truth, that is the strongest possible indicator that there is an exceptional public interest in granting a remedy. My learned friend refers to Warby. Again, Warby does not address this specific question, but the relevance of Warby is to the public interest and perhaps I could ask the court to take note of paragraphs 113 and 119. Key issue there is that Parliament do not have the full picture. And then my submission, that's a relevant consideration to exceptional public interest. Turning to the question of remedy, my learned friend submits that if this court makes a declaration of receipt or quashes the regulation, the orders, there is concern about over-remedy. But it would be a matter for the Crown Court to decide whether to permit appeals out of time, and whether to grant an appeal in any specific case would depend very much, I submit, on firstly the form of any new legislation. If it's in exactly the same form, then permission might very well not be granted. If it was to be different for a particular vulnerable group, and an appellant was to fall into that vulnerable group, then the position might very well be that an appeal would be permitted. And in my submission, that would be entirely just.
That's in relation to people who are out of time.
Yes.
But suppose that last week somebody was properly convicted under the current orders, and this court quashes the orders so they have had no legal effect at any time, and suppose that they're not someone who has a disability or has been the victim of domestic abuse or anything like that. So it's purely adventitious that the legislation under which they have been correctly convicted has now been quashed by this court. You would say, well, they're entitled to the benefit of that.
Oh, yes. They might very well be convicted again under similar legislation. Assuming they continued to commit the offence. But in my submission, that is the right place for the court to draw the line. In situations in which people will have been unlawfully convicted. And it is right to...
Well, when you mean unlawfully convicted, what do you mean by that?
That people will have been convicted during the period between 1st of February and 30th of May 2024, when on any view the legislation was unlawful.
The convictions were valid and subsist.
Yes, but based on unlawful legislation. They are valid now, but it is wrong that they should be. And over the short adjournment, my lady and my lords, we did find some newspaper reports which confirmed that there were convictions in that period, which is, as a matter of common sense, what anyone would have expected, bearing in mind what was happening at that time. So we can provide the details if the court wishes to receive them.
I think the time to provide evidence is below,
I
not
think it
before
probably,
this court.
yes, I accept that. But it was a matter of common sense that it was going to happen. And it is right that a limited declaration of the Hurley and Moore sort is not what we seek. And querying in any event what the effect would be in criminal convictions of an order of that sort. But in my submission, even that would be preferable to the approach taken by the learned judge, which was simply to consider whether the outcome would have been different for these claimants, and then to find, without further consideration or explanation, that there was no exceptional public interest. Unless I can assist the court further.
Thank you. We'll rise for a moment. Thank you.
Court rise if able.
is right in the Court of Appeal.
You're right, basically. Court of Appeal treats point parts of the sentence. That's the ground on which you can appeal. I think the judges point out the Constitution.
So the
Lost
rubbish.
in the wash.
Yeah. It's nonsense.
Yes, there's a reference to it. But that's the reference to it there. It's probably like the stuff under there, to be honest. And depending on what they're going to do, we can send them a copy of that. So they've got it. Obviously, may or may not want to say anything about the other point about the where anything that was said in the judgment was in all reply, and there are references to it in the PTA application submitted to the judge, which she appended to the PTA.
Your Majesty's do a bit of a draw.
We can just I think
Get the six. I don't think our skeleton, any skeleton below is in the courtman.
they have one, but they don't.
Where are
Let's
they?
get the skellies are in.
Our skellies below.
Both ours and the claimant skellies.
Well,
Yeah, there are some of them towards the end.
it's up.
Claimant, yeah, it's all page 237 and following.
Oh,
But the don't mention it actually, 2A at all.
237.
273, I think. Did I say it? Did I say 237? No, I probably said 237.
Yes, it's in the court.
Core bundle, yeah. I scrolled on it. Not doesn't address the 231 2A now in 32B.
Yeah. God.
Ours did, yeah. Well, only 31 2A.
Seven.
278. No, hang on. 278.
Was it raised in our DGs?
Yes, it is. DGs 232. 232 para 66.
Mm.
Over the page, 233. So we delete it. We get the response. We write it and
Yeah.
reply. 232, then over the page to 233.
Mm.
At the top.
Yeah.
is able.
Mr. Madahi, Sir James, thank you to you, and also thank you to Mr. Westaway and Mr. March for their assistance in relation to this case. And obviously, all those who've engaged in the preparation of this appeal, we're very grateful to you. We're going to reserve our judgments in this case, or judgment in this case. There's only one matter, apart from the obvious things to say, of which I know you're fully familiar, no re-argument, etc. And draft will be circulated, and no need to tender the hand down unless you're asked to do so, and then to endeavour to agree a draft order in advance. Would provision of the material by Friday lunchtime be possible? That is, any reference in any of the documents that were before the court below, and that we haven't yet seen, that relate to the matter, the specific matter raised under 2B in this appeal, if those could be provided to us in an agreed form if possible.
And our side certainly.
Thank you very much. All right.
The court rise is able.